Thank you.
I'm Bruce Lavery and I will be appearing on behalf of the respondent, Secretary of State for Defence. This is my colleague, Abba O'Callaghan.
Thank you. Okay, will you start now?
If it pleases your ladyship, I'd like to commence with my first point of appeal, which refers to the issue of locus standi. In the case before us today, would your ladyship appreciate a brief overview of the facts of the case?
I think that would be useful.
Okay. The campaign for nuclear disarmament was brought to their attention that the Secretary of State for Defence had announced at the Army base in Porton in Salisbury that they would begin research and testing on advanced nuclear weapons. Under documents assessed under the Freedom of Information Act, the reasons for selecting the Porton site included the local clubbing scene, but had made no mention of the well-known state-of-art facilities at the site.
Could you explain what you mean by the local clubbing scene?
This would be the socialising and out of work activities by the workers. The CND thought that this idea of the local clubbing scene was relevant to the considerations and should not have been taken into account. So it took the issue to judicial review and it was found against. So this is what our appeal is going to be about.
Thank you.
What's
the basis of your appeal then?
Yeah, my first point of appeal is that the CND it was found that the CND did not possess a locus standi because of insufficient numbers of members in the Salisbury area. We submit that this is not the case. I would like to draw the Court's attention to the case of the Crown and the Inspector of Pollution ex parte Greenpeace Limited and another number 2 from the year 1994, volume 4 of the All England Law Reports, page 329. Would you appreciate a brief summary of the facts?
I would.
This involved a company which was authorised to discharge radioactive waste from their plant. They applied for new authorisations and before these were given, they started testing the plant. The Greenpeace decided that this was divergent from those originally authorised. It was found in the case that Greenpeace did have a locus standi, but the defendant had not acted unlawfully. I'd like to refer to a statement made by Lord Justice Otten, which we found at page 4 of our bundle, which says that which deals with the sufficient interest for locus standi. He says that sufficient interest emerges from section 31, subsection 3 of the Supreme Court 1981. No application for judicial review shall be made unless the leave of the High Court has been obtained in accordance with rules of court, and the court shall not grant leave to make such an application unless it considers the applicant has a sufficient interest in the matter to which the application relates. He goes on to say, which is at page 3 of the bundle, that Greenpeace had a sufficient interest to amount to locus standi to challenge the decision to vary the existing authorisation. It had national and international standing and was an entirely responsible and respected body with a genuine concern for the environment. This concern led to a bona fide interest in the activities. We would submit today to the court that CND was a national organisation, as was Greenpeace. It may not have been international, but it was a national organisation, and it was respected and responsible, and did have a genuine concern for nuclear disarmament. Lord Justice Otten went on to say, which is at page 4 of the bundle, it is appropriate to take into account the nature of the applicant and the extent of the applicant's interest in the issues raised, the remedy Greenpeace seeks to achieve, and the nature of the relief sought. As I've said, CND was a national organisation which had clear interest in the issues. The remedy that we would seek would be for the review of the judicial review should have allowed the case to have been heard in the first point, and that the Secretary of State should have taken relevant considerations into account. I'd like to draw the Court's attention to the Human Rights Act 1998, section 7, subsection 3, which can be found at page 5 of the bundle. In this section it says, if the proceedings are brought on an application for judicial review, the applicant is to be taken to have a sufficient interest in relation to the unlawful act only if he is or would be a victim of that act. The potential victims in a nuclear disaster, which may happen at the plant with these new new things that are going on at the plant could be far and wide and can spread to a really large area. So I would say that the original court, when he found that there was not a sufficient number of people to have a sufficient interest, would have been inaccurate in this decision. I'd now like to draw the Court's attention to the case of the Crown and the Secretary of State for Foreign Affairs and Commonwealth Affairs ex parte World Development Movement Limited from 1995, Volume 1 of the Weekly Law Reports, page 386. Would you appreciate a brief overview of the facts of this case?
Would you please?
Yeah, this involved a British consortium which sought aid and trade provisions for a project to construct a hydroelectric power station in Malaysia. The Overseas Development Administration said the project was uneconomic and would not be a sound development project. The Secretary of State approved these anyway, and this went to judicial review. The application was granted. In this case, Lord Justice Rose quoted from Lord Diplock, which can be found at page 6 of the bundle, that it would be a grave lacuna in our system of public law if a pressure group like the Federation or even a single public-spirited taxpayer were prevented by outdated technical rules of locus standi from bringing the matter to the attention of the court to vindicate the rule of law and get unlawful conduct stopped. Lord Justice Rose goes on to say that an applicant can have locus standi because of his sincere concern for constitutional issues. We would submit that this is the case in our client CND today. He also states that standing should not be treated as a preliminary issue, but must be taken in legal and factual context of the whole case. The merits of the challenge are an important, if not dominant, factor when considering standing, and that the significant factors which would be taken into account would be the importance of vindicating the rule of law, the importance of the issue raised, and the likely absence of any other responsible challenger. The issue is extremely important as it involves nuclear weapons, and it's unlikely that there would be another challenger like CND to take this application. The nature of the breach of duty against which our relief would be sought will be covered by my learned friend in a moment. Finally, I'd like to return to the case of the Crown and the Inspector of Pollution ex parte Greenpeace, in which Lord Justice Autumn made one important point. This can be found at page 8 of the bundle. It seems to me that if I were to deny standing to Greenpeace, those they represent might not have an effective way to bring the issues before the court. There would have to be an application either by an individual employee or a near neighbour. In this case, it is unlikely that either would be able to command the expertise which is at the disposal of Greenpeace. Consequently, a less well-informed challenge might be mounted, which would stretch unnecessarily the court's resources and which would not afford the court the assistance it requires in order to do justice between the parties. This is in fact a policy reason, but I think it's quite important in view of our fact today that if CND don't take this application, then who else will be able to do it, and this could have ramifications later. So, just to conclude my main point, I would submit that CND is a nationwide organisation, but it does have sufficient interest in the case. The potential impact of nuclear weapons is very large, as they are being tested and researched in this area. London and major cities are a mere 80 miles away from Porton Down. Therefore, CND would have sufficient locus standi.
Thank you very much. Thank you.
Thanks.
Okay, can I hear now from the respondents?
Pleases your ladyship, I shall continue the case for the respondents. I'll first begin with issues raised by my learned colleagues in the case of R and Inspector of Pollution ex parte Greenpeace Limited. Greenpeace was given the standing. Fair enough. However, the sufficientness, is it there? In the case it was found Greenpeace had a sufficient interest. But what is a sufficient interest?